Hello viewers, welcome to Ekam IAS Academy. As part of today's video, we are going to look into the Office of Governor. Why we are discussing the Office of Governor is today, if you have seen in the news, Telangana Governor, that is Mrs. Tamilisai Soundararajan, she has resigned to the post of Governor. She has been working as the Governor of Telangana as well as Lieutenant Governor of Puducherry also. So in this context, she has resigned to contest for Lok Sabha elections, upcoming Lok Sabha elections from the state of Tamil Nadu. In this context, we'll know the office of governor, what are the constitutional provisions, what type of powers normally the governors enjoy, and most of the times in when we are studying about the office of governor in polity and constitution, most of the students get confused between the discretionary powers of the governor. So, what are the discretionary powers available to the governor? What type of constitutional discretion is provided, and what type of situational discretion is provided? We'll see. Then, why she has resigned? Okay, so being a governor, can't she allow or can't she be allowed to contest Lok Sabha elections is a question, right? So we'll know into the office of governor, what is meant by the office of governor, what are the constitutional provisions related to office of governor, and what are the Supreme Court judgments related to it. So previously, some people were disqualified on the grounds of office of profit. Okay, so we look into all these issues. Why this topic is chosen? Because it is the most important topic for any upcoming exams like UPSC prelims or TSPSC Group 1 prelims or Group 2 also, because most of the times this exam, like if you see in the newspaper, all the time governors and governor related issues are all the way coming in the news because of different reasons. For example, sometimes we have seen in the case of Tamil Nadu that Tamil Nadu governor's matter even went to the Supreme Court that they haven't give assent, he doesn't give the assent to the bills on time. He's reserving the bills unnecessarily for the presidential consent. Like this, because of these reasons, Tamil Nadu government even approached the Supreme Court of India also. So in this regard, not only there previously when she was the Telangana governor at that time also, there is some confrontation between the state government and the Raj Bhavan. So at that time we'll understand. So because of different reasons, in vice chairman's appointment, like vice chancellor's appointment in universities has become controversial. In many other reasons, okay. And if you have remembered, just 1 month back, we have the Punjab governor also, Banwarilal Purohit. He also resigned, but because of different reasons, citing health reasons, he resigned from his post. So we'll understand what is the backdrop of this issue and the constitutional provisions from examination perspective. So without any further delay, let's start. As part of today's video, we are going to look into the office of governor, why it is in news, where was it for borrowed from, what are the constitutional provisions, so is there any provision of removal of governor or the term of governor. We'll see the provisions and all the necessary things you need to know from the office of profit. These are the main things which we are going to discuss. Then let's see the syllabus mapping. It forms part under GS paper 2, polity and constitution. If you see this main issue, why it is in news, because Tamilisai Soundararajan, who acted till today as the Telangana governor and Puducherry lieutenant governor, she resigned to contest Lok Sabha polls. Now the question is whether the governor can resign on his own or on her own means, yes, they can do on their own. But for whom they have to submit the resignation means they have to submit the resignation to the President of India. Because who is appointing them? Again, under Article 153, we have a provision. 155 deals with the appointment of governor. So, what 153 says about the office of governor, they shall be a governor of each and every state. But again, subsequently, there is an amendment passed to that provision. So, we'll know all these things in the subsequent lecture discussion. We can understand. But before that, we need to know from where we have taken the office of governor. From which particular source means it is right from the Government of India Act 1935. Government of India Act 1935, from which we have taken the office of governor. Then what happened? But if you see the office of governor, there is another provision also borrowed from another country, that is appointment of governor by the center. This was not taken directly from the Government of India Act, but from a Canadian Constitution. That means with respect to appointment, because in the recent times, if you see also, right from the beginning, who is appointing the governor? Governor is getting appointed by the President of India, but that appointment will be based on the aid and advice of the central government to the President itself. That means the center's role in appointment, this particular provision we have taken from Canadian Constitution. Why? Because Canada is a strong federation, no? Whereas in USA they're directly elected by the people. But in India, we didn't prefer the direct election to the governor, because again that will create a rift between the elected representatives on one hand, like the chief minister and ministers and the governor on the other side. That is why we have opted towards the Canadian Federation. This is the main thing which you need to know from the borrowing point of view with respect to the office of governor. Then what are the constitutional provisions of office of governor? So you need to know article 153 says there shall be a governor for each and every state. That means for every state one governor should be there. Then same person can be there for another state or two more states, means yes, this provision was facilitated by 7th constitutional amendment in 1956. If you have remembered, the same amendment also has created State Reorganization Commission, SRC we have, and also the same provision created Officer for Special Linguistic Minorities. No, this is a constitutional post you have, under which we have Article 350B. This is a constitutional post, one man post. Okay, so the same constitutional amendment. So this is what you have to remember. Then, as I told already, 155 deals with appointment of the governor by the President of India. Don't think that governor will be chosen by the president according to his whim or choice. It is not according to his wish, but on the aid and advice of the Council of Ministers to the President of India. Then 156 deals with removal of governor. Okay, so he can be removed any time from his office. There is no stipulated grounds set by the constitution that on these grounds only a governor can be removed. Okay, there is no security of tenure also with the governors. That means normally governor as a practice he is given a tenure of 5 years, but it can be long also. Within this 5 year tenure, it doesn't mean that completely he has to completely devote 5 year term to one state only. So he can spend 2 years in one state, 2 year another state, and 1 year in another state also. Together it can become 5 years also. And another important thing we need to remember is here this 5 year tenure is not prescribed by the constitution. Okay, so just constitution said he holds office during the pleasure of president. Pleasure of president means president has a total discretion to remove the governor without any reason on at any particular moment, you can say. That means without any fault also, or without any stated ground. Or like for example, if you have seen the judge of a Supreme Court, how he can be removed means in case of proved misbehavior or incapacity. There are stipulated grounds. For example, President of India, when he can be impeached means for violation of constitution. Like this, some grounds are specified. But for the office of governor, there is nothing mentioned as such by the Constitution of India. But they clearly mention that there is only one provision, that is for in case he doesn't have the pleasure of president, then he can be removed by the President of India. So these are the provisions related to the appointment and removal of the governor. So next what we have to see is regarding term we already have seen. Then with respect to the salaries and all, that will be determined by the state legislature. So normally here another main thing you have to remember is not only what is his constitutional role, means two roles were prescribed by the constitution to the governor. One is he should act like agent of center. What is the meaning of agent of center means? So being in the state, okay, as the constitutional head, he has to monitor how the state administration is being run. So whether the state administration is being carried in accordance with the constitutional provisions or not, these things have to be checked by the governor. Then at the same time, he should also act as the state executive head. So he will be the executive head of the state. So then what is the main purpose? Whether he's a real head and a nominal head means he's not the real head. Real head will be the chief minister along with the council of ministers. So then he is the nominal head, or you can say titular head. Only namesake he will be having the powers. Okay. So this is what you have to keep in mind. Constitution has given the dual role with respect to the office of governor. Then apart from this, constitution has given so many powers to the governor. For example, legislative powers are there, like with respect to bills, summoning, proroguing the houses, dissolving the state assembly. Like this, there are some provisions. Executive provisions are also there, like appointing some particular post, like state public service commission or state election commissioners, or even state HRC members. Like this, some provisions were given to the governor in executive domain. But at the same time, some legislative, executive, and judicial powers are also given. What are the judicial powers? He can appoint district judges or the next judicial officers within the state. Like this, some provisions. And when he was also consulted when the chief justice of that particular state will be appointed, okay, by the collegium system by the President of India based on the collegium recommendations. Like this, some judicial powers are also there. And financial powers, like budget document has to be tabled only in the assembly with the prior permission of the governor. Like this, we have some other powers also given. But at the same time, there are some discretionary powers given. Discretionary means what? In his own. Okay. So normally, what is Article 163 saying all the time? The governor should exercise the powers, whatever that is prescribed by the constitution. For most of the times, he has to rely on the aid and advice of the Council of Ministers. This is what prescribed by the Constitution of India. Okay, aid and advice of the Council of Ministers. But in some situations, there is discretion provided. That means without listening or without adhering to the advice of the Council of Ministers, he can take some personal decision. That means some discretion is allowed in the by the Constitution sometimes, and some situational discretion is also there for the governor. So then we'll understand what are these discretions also. Then let's see what are the further topics we are going to discuss. So here you can see constitutional provisions already. These all the provisions deals with the state executive. Who forms part under state executive? It is the office of governor, then council of ministers headed by the chief minister you have, and advocate general. Advocate general at the state level and attorney general at the central level. So these will be forming part of the state executive. So all these will be covered under 153 to 167 under part 6. Part 5 is union executive, right? Then do remember, like vice president, there is no office of vice governor in the state level. And second thing you have to remember is he is only a nominal executive. Real executive is the chief minister along with the council of ministers. Then we also have discussed about the dual role, and I told you about the seventh constitutional amendment which facilitated that single person can be appointed as governor for two or more states. In this case of Tamilisai Soundararajan, she was acting as a governor for both the state of Telangana and the Union Territory of Puducherry as lieutenant governor. So two things are possible now. So the term we have seen 5 years, but pleasure of president is very much important. And resignation can be done anytime to the president of India. President may can transfer also. As I told you, 5 year tenure need not be spent in one state also. Okay. So he can be transferred within that 5 year within, okay, for the rest of the term and all. So normally, whatever the decision, why he has been removed by the president suddenly, the pleasure of president cannot be questioned in any courts. That is what pleasure of president is not justifiable. This is the most important thing you have to remember. After seeing APPSC Group 1 prelims polity related questions, these type of things can be asked because they didn't ask any direct question in polity. So previously, every student, most of the students used to feel polity is very easy for them. But nowadays, it is becoming difficult for many exams because that change in the nature of questions. So you need to change with the pattern also. Then if you see, there is no security of tenure because he can be removed anytime. There is no ground laid by the constitution that already we have seen. And he holds office during only 5 year tenure. And if that 5 year tenure process, but there is no successor appointed by the president of India. Till successor assumes the office or charge, till then he can continue even that is crossing 5 year tenure. This is another important fact you need to know. And there must be a governor. That is what 153 is saying. There shall be a governor. So as it is must, he has to continue till successor will be appointed. So these are the provisions which you need to know. Then what are the discretionary powers? If you see here, we have two main discretions. One is constitutional discretion. That means constitution itself has prescribed this discretion. So when it was given, when the bill has to be reserved for presidential consent. Okay. So for example, if it is endangering the position of a high court, or the bill is related to Article 304 interstate trade and commerce, such provisions. Okay. So in those cases, if even if it is passed by the state assembly and council, then president of India has to be consulted. So then governor, without following the Indian advice, can reserve the bill for presidential consideration. Second thing is he can recommend president rule in that state if he thinks that the state is not being run in accordance with the constitutional provisions. So at that time, not based on the Indian advice, but on his own, if he feels that he can report to the president that please impose Article 356 in the state. Then when given additional charges, administrator of Union Territory. So if you see in this case only, Tamilisai Soundararajan is being like, firstly, she was appointed as governor in 2019 to the state of Telangana. So as being as when she was working as the governor of Telangana only, later she was given additional charge of Puducherry also. So being a governor of Telangana, she cannot follow the aid and advice of Telangana cabinet in respect of matters related to Puducherry. So then also she can exercise her own discretion. These are the constitutional discretions means that have been prescribed by the constitution itself. But sometimes some discretions are situational, means when the situation arises, at that time governor can take his own decision also. So in what situations? For appointing the chief minister's office, when no party has clear cut majority, in case of hung assembly, or if the like the prime chief minister dies but there is no successor, then also like their choice or their particular decision can be taken. And then in case of the council of ministers are not able to prove majority on the floor of the house, that means they have lost majority in the house, at that time also he can dismiss. At that time he cannot ask or he cannot rely on the aid and advice. So without asking their aid and advice, he has to dismiss the council of ministers, and he has to dissolve the assembly when it loses majority. So these are the three situational discretions we have and three constitutional discretions you have, okay, with the respect of office of governor. Then we look into what is office of profit. Office of profit means, so any post, okay, so for example, if they are in any government of India or government of state post, okay, so if they're receiving any financial or monetary benefit from the government, then they will become ineligible to contest for some other post. That is what office of profit means. So the positions held by members of parliament or members of state legislative assemblies which provide financial gain will be disqualified, okay, so for contesting other posts. So from where we have taken this means UK, okay, whenever you're reading any constitutional provisions, try to check its origin or the source from where we have borrowed. So then you have to remember, neither the constitution nor the representation of people's act 1951 defined this office of profit. That is why, as there is no clear cut definition, so many cases were filed with respect to office of profit, and whenever the case is before the Supreme Court, then the case was decided based on that particular matter. So Supreme Court has given lot of interpretation with respect to office of profit. One such case happened in case of Pradyut Bardolai versus Swapan Roy case in 2001. So in this case, what happened? They have given some set of factors that need to be tested in case if it falls under office of profit or not. So one such thing is whether the government is responsible for appointing that individual or not. Here, if you see in the case of office of governor, who is appointing it is by the president on the advice of the government only, no. So here the government is responsible for appointing. So it falls under office of governor, okay, office of profit. Then if the government has the authority to terminate the appointment, yes or no, pleasure of president means, and if the government sets remuneration of the position. So in this situation also, okay, so as the governor who is setting the remuneration of the governor means it is again the government only, no, state government will determine. So based on these things, what okay, so what is the source of remuneration, extent and all. So based on these positions, it will be determined whether it is office of profit or not, okay. Then we look into what are the constitutional provisions. What did Article 102 clause 1 say? It is saying that a person who is having office of profit, okay, so he will be ineligible to contest as member of parliament or under the state government, okay. That means he will be disqualified whenever he holds this office of profit. That is what 102 clause 1 is saying. Then what is this article 103 saying? So in case if there is a question arising with respect to disqualification on the grounds of office of profit, then who shall be the deciding authority? It is the president of India, and his decision is final. Like anti-defection presiding officer's decision is final. But what happens is here the president of India has to consult election commission of India, and he has to take the opinion of the election commission. That is what you have to keep in mind. Then same provisions are there for state legislature is 191 clause 1 you have, and 192 same applies for the state legislature. But do remember, there is also a provision in the Representation of People's Act 1951 which is saying that in case if the person, okay, so if he is having any contract with the government for supply of any goods and services undertaken by the government, then also for the trade and business purposes also it forms part of office of profit. If you have remembered, in the recent case only, Jharkhand Chief Minister Hemant Soren, okay, so when this person, when this Hemant Soren was the Chief Minister of Jharkhand, at that time there are so many accusations made against him that he had some interest in the mining lease business, and all his family was involved and all. So that is based on this particular provision of Representation of People's Act itself. So then we'll see why. Now if you see here, what are the posts that were excluded from this office of profit? This is what you have to keep in mind. So some posts were given exemption because, see here, like any person, if he's holding any office of profit, then being in that particular post, you cannot contest for any other post. But some positions were given exemptions. So that means if even if they hold these positions, they don't form part of Office of Profit. So under this particular law, that is Parliament Prevention and Disqualification Act of 1959, it was amended multiple times and expanded. So many offices were added. But what the currently main important offices means, Minister of Union or State. That means a state minister or a union minister will not be disqualified on the ground of Office of Profit, and leader of opposition in the parliament or state assembly. At the same time, chairman of Nation Commission for Minorities, Scheduled Caste, Scheduled Tribes, Women, and any other government bodies for in which even if they're in advisory role also, those are all excluded. Okay, so from the Office of Profit. Okay, this is the act. Then we'll understand why it is a ground for disqualification. So why it is a ground means, if you see, the first thing, it is upholding the constitutional responsibility. So in case if you're having two tasks, okay, you may not fulfill the constitutional responsibilities of the particular post, no, by holding two things at the same time. So this becomes a difficult thing. Then separation of powers. If you see this Office of Profit law, it is one of the basic feature, like, because separation of powers is given. So in case if you are being part of executive and if you are part of legislature, then it is clear violation of separation of powers. No? That is why this is disqualified under this different provisions. Then ensuring checks and balances. So there should be immunity, there should be independence from one particular department or one particular organ of government and another organ of the government. Okay, so for this reason also this was given. Then preventing the conflict of duties or interests. So this is also the main provision, because so most of the times if you're involving in two posts or more, then you will have definitely the conflict of interest may arise. To prevent these things, Office of Profit is a disqualification ground for different posts. Okay, then if you clearly see in one of the provision of the Office of Governor, in the qualifications of governor only, two main things are prescribed by the Constitution. One is citizen of India and 35 years of age. So these are the only two things stipulated by the Constitution to become eligible for the Office of Governor. But at the same time, second provisions are mentioned is they should not hold any Office of Profit. Okay, so that is why. And if you see MPs also, for example, now here Tamilisai Soundarajan wants to contest for Lok Sabha. No? What is Lok Sabha MP qualifications? Citizen of India, then 25 years of age, and she should not hold any Office of Profit. This is one ground. So if any Office of Profit is held by this person, so then it becomes a ground for disqualification of their election also. That is why she has to resign. Okay, so these are the things which you need to know. Then let us look into some examples related to the Office of Profit. Means in this is the first instance. Like recently we have seen in the case of Jharkhand Chief Minister. That means previously also so many instances were there. In 2006, when Samajwadi Party Rajya Sabha MP, the wife of Amitabh Bachchan, okay, you have, she is Jaya Bachchan. No? So at that time she was accused of holding a post of Uttar Pradesh Film Development Corporation and all. Later, for that particular post, being a Rajya Sabha member, holding a corporation chairman post is again Office of Profit only. That is what. And then Election Commission has disqualified her on the grounds of Office of Profit. Same thing happened in 2018 also, when Delhi MLAs, okay, so they were Legislative Assembly MLAs were appointed as Parliament secretaries. At that time also disqualified by the Election Commission, by the President of India, based on the Election Commission's advice only. Then in 2022, as I told you already, Jharkhand Chief Minister was accused only, but notice was given. Subsequently, those allegations were removed. Okay, in this way you have to remember. So there are some cases also, you can write these recommendations. Then what is the way forward means, ARC, second ARC has recommended that almost all the time. Okay, so there should be amendment to the Representation of People's Act to include the definition of Office of Profit, so that we can minimize these provisions from happening, or these instances from happening. And even Venkatachalaya Commission we have now with respect to National Commission to review working of Constitution, that also suggested that Election Commission should be given powers to determine what is Office of Profit or not. So like this, various recommendations were given in this regard. So this is all with respect to the Office of Governor and Office of Profit. Now let us see the prelims question given for practice in the previous video. You can see first one, Election Commission of India is 5-member body. No, it is 1 plus 2, 3-member body only. So you can rule out first statement. Then Union Minister of Home Affairs decides the election schedule for conduct of both general elections and by-elections. This is also ruled out. Okay, so you have only 3. Without knowing the third statement also, you can answer just by knowing 1 and 2. So, but the election commission resolves a dispute relating to splits and mergers. That is also correct. So, answer is 3 only. This was given in UPSC prelims once. Then let us see the practice question given today. Which of the following statements is not correct with respect to the office of governor? Read the following statements and try to answer in the comment section which is the correct one. Then the mains question given for practice. Has the governor been acting as more an agent of center rather than being the constitutional head of the state? Analyze in the recent controversies involving the post of governor in India. So this is the mains question given for practice. Try to answer and put your answer in the comment section. Then as we have come to the end of the video, today we have seen why we are discussing the office of governor because Tamilisai Soundararajan has resigned as the governor. So to contest Lok Sabha polls. In this context, we have seen constitutional provisions related to office of governor and what is the office of prophet, what are the constitutional provisions and what are the Supreme Court judgments in this regard. So this is all with respect to this video. I hope you found this video useful as part of your preparation. Thanks for watching. Have a good day.